All right, everybody. Now we are going to be talking about the jury instructions. A lot of people have been asking me, so I figured again, rather than trying to decipher them on Twitter, trying to figure out through Twitter, uh, why not just simply make a video about it? It seems a lot simpler, right? So that's what we're going to do. We're going to review the jury instructions live on stream, and we are going to discuss what they are, what they mean, and so on and so forth. So this is non-alcoholic champagne, by the way, anybody wondering. So we're going to go page by page, line by line. Most of all, I understand people have been saying, well, hold on a minute. What if they don't understand? What if they make an incorrect assessment or determination, or none of that matters. Literally, none of that matters. Jurors can get the entire law wrong, and you'll never know about it. And their decision is final. There's no mulligan. There's no backseas. There's such a thing in law known as jury nullification. You can't talk about it. It's usually grounds for a mistrial, but it's always lingering underneath the surface. You know, I always make that interesting story about the bus tumbling down a hill filled with children, and the bus driver, let's say, had a heart attack and passed away. You're walking around intoxicated, and if you don't intervene, you know, that bus full of children they're all going to die. 20 children are going to go off a cliff. Well, you intervene, jump into the bus, and then you get arrested for operating a motor vehicle, that bus, under the influence. It's a cute charge, because any jury in the universe would be like, he's the hero. He was just in the right place, right time. So what that he was intoxicated? Even though you'll meet all the elements, you were under the influence, operating a motor vehicle, all checks out. The problem is you will still end up with a charge potentially, and that charge will never stick because there's not a jury in the universe that'll be like, oh yeah, guilty. You know, you're a hero at that point. So let's go over it. There's a lot to go through. There are about 38 pages. So I'm going to try and move fairly quickly because I don't want to linger too much. But impartiality. This is the first instruction. We're going to go instruction 1 through whatever. You have been chosen and sworn as jurors in this case to try the issues of fact presented. Obvious. You must consider and decide this case fairly and impartially. You are to perform this duty without bias or prejudice as to any party. By the way, notice super chats are still disabled, so I can focus on this without getting distracted. You are to perform your duty without bias or prejudice as to any party. All persons stand equal before the law and are entitled to the same treatment under the law. Our system of law does not permit jurors to be governed by sympathy, prejudice, or public opinion. Both parties and the public expect that you will carefully and impartially consider all of the evidence in the case, follow the law as stated by the court, and reach a just verdict, regardless of the consequences. I mean, look at that. Even the court is almost like, yeah, please follow the law as stated, consider all the evidence, but at least reach a just verdict. I mean, it's almost like the court is saying you can nullify without saying you can nullify. That's very unique language. Normally, like, I don't get this kind of language because this is a civil case and I mostly try criminal cases. All right. Instruction. Wait, did we? Whatever. Credibility of witnesses. You are the judges of fact, the credibility of the witnesses and the weight of the evidence. So they decide. You know, you are the judge, jury, and executioner. You've been sitting there, you were listening carefully, and all of this information is absolutely crucial because the jury is the one that gets to weigh it all. They were there, and you know, as they say, oh, sorry about that. You know, you were there. I was there. Let me tweet this out real quick. Let's decipher the jury instructions. Here we go. So that people come in and they know that I'm doing this on Twitter as well. All right. So They are the ones, because they're there for the entirety of the trial. All outside influence has been removed, and they get to watch the video, listen to the audio, watch the witnesses, listen to the witnesses, and judge more than just what they hear and see. See, this is crucial. This is like probably the most important instruction in this entire piece. Okay? The credibility factor. Because we all know Amber Heard did not appear very credible. And for them to hear that, oh my God, we can take this into consideration, is essential for them reaching a just conclusion, hopefully for Johnny. You may consider the appearance. Listen to this language. I mean, it's just like chef's kiss. You may consider the appearance and manner of the witnesses on the stand, their intelligence, their opportunity for knowing the truth and for having observed the things about which they testified, their interest in the outcome of this case, their bias, and, if any have been shown, their prior inconsistent statements, or whether they have knowingly testified untruthfully as to any material fact in the case. I mean, listen, I'm going to read that again, that last part, because it's like, holy shit, nuclear bomb right there from the judge's mouth. And people respect judges. The jurors really respect judges. They listen to judges. Judge tells them strike that testimony. They're like, okay, we're going to ignore that. Judge yells at a lawyer like, oh, that lawyer did a bad no. Judge tells them you shall have you will note any prior inconsistent statements and whether they have knowingly testified untruthfully as to any material fact in the case. They're going to go, okay, that's all we needed to hear. Thank you very much. You may not, things they are not allowed to do, arbitrarily disregard believable testimony of a witness. So if they found someone believable, you can't just automatically disregard. It kind of goes hand in hand with paragraph 1. However, after you have considered all the evidence in the case, then you may accept or discard all or part of the testimony of a witness as you think proper. Hint, hint, Amber Heard, wink, wink. You are entitled to use your common sense in judging any testimony. From these things and all other circumstances of the case, you may determine which witnesses are more believable and weigh their testimony accordingly. Okay. Next. Verdict not to be based on sympathy, bias, guesswork, or speculation. Again, kind of goes hand in hand with impartiality, instruction 1. Verdict, you must not base your verdict in any way upon sympathy, bias, guesswork, or speculation. Your verdict must be based solely on the evidence and instruction. So this is kind of like anti-jury nullification. You can't just be like, we really feel sorry for this witness. Liability issues. Now we get to the meat, right? Now we get to the meat of the actual case. So up until this point, it was all basically prelude. Your verdict must be based on the facts as you find them and on the law contained in all of these instructions. Excuse me. With respect to plaintiff Mr. Depp claims against Ms. Heard, the issues in this case are summarized below. Number 1, whether Ms. Heard made or published any of the following statements. Quote, A, quote, Amber Heard, I spoke up against sexual violence and faced our culture's wrath. That has to change. Then 2 years ago, B, quote, then 2 years ago, I became public figure representing domestic abuse, and I felt the full force of a culture's wrath for women who speak out, end quote. And C, quote, I had the rare vantage point of seeing in real time how institutions protect men accused of abuse, end quote. So whether she made or published, that's the first question. The second, do any of Ms. Heard's statements imply or insinuate anything about Mr. Depp? See, because they got to tie the two together in their heads. 3, were Ms. Heard's statements seen by anyone other than Mr. Depp? Number 4, did Ms. Heard's statements convey a defamatory implication? See, this is the defamation claim to someone who saw them other than Mr. Depp. Number 5, are the implications or insinuations about Mr. Depp and Ms. Heard's statements false? See, the elements of defamation, they're starting to come to life in these instructions. Number 6, did Ms. Heard make the statements with actual malice? Because Johnny is a public figure, you must have actual malice. See, there's a popular case, the New York one. If Mr. Depp is entitled to recover, what is the amount of Mr. Depp's damages? On these issues, Mr. Depp has the burden of proof. So if you decide, 1, 2, 3, 4, 5, and 6, yes, then you get to decide number 7. Now, your decision on these issues must be governed by the instructions that follow. So let's get in even deeper, right? These are the liability issues we are talking about. With respect to Ms. Heard's claims against Mr. Depp, the issues in this case are summarized below. Number 1, did Adam Waldman, while acting as an agent for Mr. Depp, make the following statements? A, quote, Amber Heard and her friends in the media use fake sexual violence allegations as both a sword and a shield. This is Mr. Heard's claims, of course, depending on their needs. They have selected some of her sexual violence hoax facts as a sword, inflicting them on the public and Mr. Depp. B, quote, quite simply, this was an ambush, a hoax. They set Mr. Depp up by calling the cops, but the first attempt didn't do the trick. The officers came to the penthouses, thoroughly searched and interviewed, and left after seeing no damage to face or property. So Amber and her friends spilled a little wine, roughed the place up, got their story straight under the direction of a lawyer and publicist, and then placed the second call to 911. So they're like, oh, we fucked it up. Let's fix it up and try again. And C, we have reached the beginning of the end of Ms. Heard's abuse hoax against Johnny Depp. So, number 2, are any of these statements are about Ms. Heard that they have to decide? 3, were any of the statements seen by someone other than Ms. Heard? Obviously, we know that's kind of a fact, but it's got to be included. It's got to be proven. 4, are any of the statements false? 5, were any of the statements made with actual malice? Because again, Amber Heard is also a public figure. And 6, if Ms. Heard is entitled to recover, what is the amount of Ms. Heard's damages? So if 1, 2, 3, 4, 5 are all straight, number 6, what are her damages? On these issues, Ms. Heard has the burden of proof. This is her counterclaim. This is where they sought $100 million. In the previous one, this is Johnny Depp's $50 million. Some people have been joking around about, oh, I hope Depp gets 150. He can't. He can't. He's capped at 50. That's what they asked for. Your decision on these issues must be governed by the instructions that follow. Now, the finding instruction. You shall only return your verdict for Mr. Depp on his on his claim for defamation, about the following statement if he has proved by the greater weight of the evidence, this is the preponderance of the evidence standard in the United States for civil cases, that 1, Ms. Heard made or published the following statement. Amber Heard, I spoke up against sexual violence, face our culture's wrath, things have to change. Statement is about Depp, false, defamatory implication, designed and intended by Ms. Heard, and due to the circumstances surrounding the publication, conveyed a defamatory implication by someone who saw it other than Mr. Depp. And if by clear and convincing evidence, this is the different standard. So here it's greater the weight of the evidence, here clear and convincing evidence that Ms. Heard made the statement with actual malice. If Mr. Depp failed to prove any one, so just one, let's say the statement is false, they're going to think, no, this statement is true, then you shall find your verdict for Ms. Heard with respect to the above statement. So they have to find 1, 2, 3, 4, 5, 6, and 7, all to be yes, 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 yes. There's only one no, a single no, claim fails, period. No exceptions. Same thing, I'm not going to reread it, but I will read the first part. The 2 years ago, I became a public figure. This is her statement, Ms. Heard, representing domestic abuse, and I felt the full force of our culture's wrath for women who speak out. Statement is about Depp, statement's false, defamatory implication, designed and intended by Ms. Heard, circumstances surrounding the publication inferred and conveyed a defamatory implication. someone who saw it other than Mr. Depp, and actual malice by clear and convincing evidence. Again, if Mr. Depp failed to prove any one of the more elements, then you should find your verdict for misheard with respect to the above statement. Now, the same thing is going to go to the third statement. I had the rare vantage point of seeing in real time how institutions protect the men accused of abuse. Same exact language, no change. We're going to keep going. Now, the same thing is going to be applied for Ms. Heard's statement, which is the Waldman statement. All three of them, right? Like they had three and they had three. So each and every single one, they get to decide. This is the Amber Heard and her friends in the media use fake sexual violence one. Then the same thing for was an ambush, a hoax. And then the same thing for we've reached the beginning of the end of Miss Heard's abuse hoax against Depp. Okay? Same thing. And if they don't prove 1, 2, 3, 4, 5 on these, Mr. Depp wins. They have to find all 5. If even one of them falls, the entire claim collapses. Now, definition of preponderance. Remember I told you preponderance of the evidence, greater weight of the evidence. They're basically synonyms. In law school, they taught us they're just an oomph above 50%. I noticed, if I remember correctly, neither Ben Chu or Camille Vasquez used the oomph above 50% argument because I don't think they need to. I think they have way more than that. I think they have more than clear and convincing. I mean, in my book, and of course I'm biased. I already admitted it from the beginning. I'm very biased in analyzing all of this. I'm 100% Team Johnny, based on everything I've seen and everything I've heard and everything I've read and everything I've listened to and everything, period. But I think they have beyond a reasonable doubt, which is a criminal standard. That's my personal perception. Again, I could be completely fucking wrong. I don't care. It's my opinion. I'm allowed to have it. So that's just me. Definition of preponderance, greater weight of the evidence. When used in these instructions, the phrase, the greater weight of the evidence, also sometimes called the preponderance of the evidence, means the evidence which you find more persuasive when evaluated against all the evidence that has been admitted in the case. The testimony of one witness whom you believe can be the greater weight of the evidence. This is extremely confusing. Extremely fucking confusing. So let's break it down, okay? When used in these instructions, the phrase, the greater weight of the evidence, every time you see that, also sometimes called preponderance of the evidence, it means, okay, the evidence which you find more persuasive. That's why it's oomph above 50. What is more persuasive? Because at 49.99999%, it's not the more persuasive. But at 50.000000001%, that's the more persuasive. That's why they say it's an oomph. They don't even use a number in law school. It's almost like a sound, like a throat sound, an oomph. Like a nasal sound, above 50%. When evaluated against all the evidence that has been admitted in the case. That's when you compare the evidence from one side to the other collectively. Now you take literally, imagine like Lady Justice, right? With all of Amber's witnesses and all of Amber's videos and all of Amber's exhibits and demonstratives, and then the same with Johnny, all of Johnny's witnesses and all of Johnny's exhibits and all of Johnny's, everything, and whichever one weighs more, that's the one that wins. That's the simplest way I can put it. So that's when you're evaluating. When evaluated against all the other evidence admitted in the case, the testimony of one witness whom you believe can be the greater weight of the evidence. Now, that's for, 1 through 6 or 1 through 5 or 1 through 4. Now, for the last one, because they're all public figures, remember this language that's been repeated? Actual malice. Actual malice has a different standard. Actual malice has a convincing, can't keep missing it, clear and convincing evidence. Clear and convincing. I like to talk about it in my cases. It is actually the same standard also that is used by the government to take away your right to raise your children. If you're found to be an unfit parent for whatever reason, that's the standard the jury or the judge have to use in order to deprive you of your parental rights. Another situation is when, let's say, if you're found to be, or you're suspected, excuse me, to be mentally incompetent, clear and convincing evidence is the standard they use to take away your rights to financial freedom, to your ability to, be able to take care of yourself, access to your bank account. Like you have to go through, but it's like you're mentally not there anymore. So it's for your own safety. Although if some of you have seen the movie, oh God, what is that movie called? It's on the tip of my tongue. I Care a Lot. If you haven't seen that movie, by the way, I Care a Lot, you need to watch it. It's on Netflix, I believe. It's on Netflix, I believe. Anyway, when a party has, now definition of clear and convincing evidence, what does that mean? When a party has the burden of proving an issue, which obviously we know, what we just talked about, actual malice, that the statement was made by the three statements and the three statements made with actual malice, what's the standard? The standard is he or she must produce, evidence that creates in your minds, here's the definition, a firm belief or conviction, firm belief, conviction that he or she has proved the issue. So here, evidence which you find more persuasive. What is more persuasive? Or E? Or E, right? Here, a firm belief. I firmly believe this. I firmly believe that. I am convinced that the Waldman statement has blah, 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 or I firmly convinced that Amber Heard publishing the op-ed blah, 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 caused all those ramifications, right? Okay. Defamation by implication. A statement that is not directly defamatory may nonetheless suggest a defamatory meaning in an indirect way that is by implication. So this is another avenue for them to find liability on either side. In determining whether any of the statements have a defamatory implication, you must consider the op-ed as a whole and the circumstances surrounding the publication, i.e. Aquaman 2, or excuse me, Aquaman. Hello. This is literally the judge saying, like, do you feel Aquaman had like some kind of influence on it in a way? You should consider if these circumstances show that the words used are defamatory and relate to Mr. Depp. However, such circumstances cannot extend the meaning of the words used in the op-ed beyond their ordinary and common meaning. So you can't just like extrapolate and create a theory of, oh my God, this is a, no, you have to stick to the facts. The proposed implication must be reasonably, there it is, literally, reasonably drawn from the actual words used. It cannot be far-fetched, okay? Defamatory meaning, consideration of the publication as a whole. In determining whether or not any of the statements in the op-ed are false and defamatory to Mr. Depp, you must read the statements in the context of the op-ed as a whole. That means you may not size in onto any word or phrase or image and be like, okay, this right here is defamatory, but everything else is not. But this right here is defamatory, and therefore, as a whole. That means you may not size in determining whether any of Mr. Waldman's statements are false and defamatory, you must read those statements in the context as a whole. This means you may not size in any of the word, phrase, same thing for the Waldman statement. Actual malice. Both parties have the burden of proving actual malice by clear and convincing evidence. To meet this burden, each party must prove by clear and convincing evidence that each statement was made or published, 1, with knowledge that the statement was false, or so recklessly as to amount to willful disregard of the truth, that is, with a high degree of awareness that the statement was probably false. Like usually you fall into that standard. Like usually it's like you just didn't give a shit. You just like, oh my God, I just received a phone call that Johnny Depp is a wife beater. And you publish an article, Johnny Depp is a wife beater. And then turns out it was some senile, someone who's just been admitted to a mental institution person who called in, who got access to a phone after hours or whatever. And you're like, oh shit. My whole career is on the line now because I just recklessly published it and it's false. And now I'm going to be sued for defamation. In this case, I think the jury, if they do, they're going to go with this one. Like she knew it was false. She knew she was making these allegations up. And if they do go this route. Actual malice is a subjective analysis that looks to the state of mind of the person who made the statement. If the person who made the statement believed it was substantially accurate at the time of the publication, then it does not give rise to liability for defamation. Let's read that again, because that is very confusing. Actual malice is a subjective analysis, okay? It's not objective. You don't look at it from the outside. It's like your own perception of it. That looks at the state of mind of the person. What were they thinking? How were they thinking about it? What was their motive? What was their intention? If the person who made it believed it was accurate substantially, then there's no defamation. Like if they honestly believe, like, I thought I was telling the truth when I wrote it, defamation falls apart. Actual malice is not ill will, hatred, or bias. That's very important for the jury to understand. The term actual malice should not be confused with the more common meanings of the word malice, because malice is confusing. Like, what is malice? Malice is someone being evil or malicious. Remember that movie Maleficent, right? The cartoon or whatever. The Disney, like the word malice, Maleficent. It's very it's difficult to understand for a lot of people. So malice needs to be defined, because then they're going to be like, yeah, she was malicious, that bitch or whatever. No, that's not what we're talking about here. It's not about ill will, hatred, or bias. It should not be confused with the more common meanings of the word malice, such as ill will or hatred. Actual malice is not established, merely because an author was motivated by ill will, prejudice, hostility, hatred, contempt, or even desire to injure another. Republication. Now, this is important because in this case, we had a retweet, right, of the op-ed by the original author. Now, this one really doesn't matter, because the jury heard her twice say, when I published the op-ed. So the rest of they probably just fell asleep during this instruction, or when they're going back to talk about it, they probably just skipped over it. In order to find that Ms. Heard republished the original op-ed, including the headline through a tweet on December 19th, 2018, you must is a very powerful language in the legal realm, but jurors oftentimes overlook it because they're not lawyers. We are taught through the law school admission test to start paying attention to these key words. Must is a huge one. Must find, it's a shall, it's a must. It has to happen. There are no exceptions. You must find that she retransmitted the defamatory material or redistributed the material with the goal of reaching a new audience. Stated differently, so it's like she took it, there's already an audience, right, for the Washington Post, and now she's like, oh, well, let me share it with my own too. Stated differently, republication occurs when the speaker has affirmatively reiterated the statement. Boom, I think. A hyperlink directing readers to a previous article on the same website does not direct the previous article to a new audience. Merely linking to an article does not amount to republication, but adding content to a linked article may constitute republication. This is for the jury to decide. You must determine whether any added content was intended to reach a new audience. If you find any content added to the hyperlink was intended to reach a new audience, boom, you've got republication. Further, if you find a republication occurred on that date, then in order to find for Mr. Depp against Ms. Heard, you must also find by clear and convincing evidence that she acted with actual malice when she republished. Definition of agent or principal. This is going to the heart of the Waldman-Depp issue. Waldman posted it because I think when they filed the counterclaim, this is my opinion, okay, again, when you're on the losing side of a battle as a defense attorney, you have to sometimes come up with garbage. You have to, because you can't just walk up there and be like, fuck, I got nothing. Let's just see what happens. You're getting paid. You have to do something. Even if it's complete shit, you have to come up with the least stinky shit that you possibly can. And the one that smells the least worst and, it doesn't look like liquid diarrhea. At least has some sort of shape that you can at least kind of like formed together and presented like, kind of looks good. You try. What do you think? And this is what I think Heard's team had when they filed the counterclaim. Because notice how it's completely unsubstantiated. Even during closing arguments, they're basically like, yeah, we got nothing through. Was it Arnold? I think Arnold, right? She was like, yeah, she lost potentially the $5-10 million here, up to like a $45 million career. I was waiting for that number, like, but you sued for 100 million. You sued for 100. Johnny had a substantial, like, he substantiated his claims. He's like, each movie can bring me about 25 million. And we know about Fantastic Beasts 3 and potentially the Pirates 6. 25 a pop, 25 plus 25 equals 50. Like, their number makes sense. Amber Heard's is like, yeah, 1 plus 2 plus 3 equals 45 equals 100. Huh? Pardon-moi? Like, they never even, I don't know. I don't know. So they had to come up with something. So their defamation claim had to be assigned to somebody. Had to be assigned because Johnny Depp never said a single thing publicly negative about Amber Heard. But they're like, what can we find? And they started digging. They grabbed shovels and they're like, let's fucking find this something. And they found it. Waldman said negative things. And they tried to imply it onto Johnny. Notice how most of it was redacted because it was like a very long article and they just found like it was needle in a haystack. I wonder how long it took them to actually find it. Like, that would be an interesting piece. Like, you could literally make a movie out of it, like seeking Amber Heard's counterclaim. Because I'm sure that took about a month of effort to craft because it was buried. It was needle in a haystack. They had to craft something out of nothing, and to assign it to Johnny Depp is a huge step. You know, a lawyer acting as an agent on behalf of the client in the statements that they make against somebody else. Oh my God, please. You're shooting for the moon in my book. You're shooting for the fucking moon. But you know what? Kudos. They found it. They needed something. They got it. Like, you got 3 bitches. We got 3 too. Go fuck yourselves. Yeah. All right. A principal is a person or legal entity with power or right to control the means and methods of performance by which another person performs the principal's work. An agent is the person who is subject to the power or right of a principal to control the means and methods of performing the work. So, like, Waldman, in his capacity as an attorney, acted on behalf of Johnny Depp when the statement was published. Express implied authority. So they have to define all these things for the jury so they understand, because obviously jurors are not lawyers. If the judge doesn't tell them, they're not going to be able to understand what the hell the judge is talking about. So, yeah. An attorney has the express authority to do everything which the client expressly authorized him to do, and the implied authority to do everything necessary or incidental to the purpose for which he was retained, like representation. Not necessarily everything I say is basically spat back onto you as a person. Like that, I don't know. Whatever. That's their claim. The judge is defining it for the jury. Let's keep moving. Ms. Heard has the burden of proving by greater weight of the evidence that Mr. Waldman. So, see, Johnny Depp's defamation claim is simple. Boom. She made statements. Well, I shouldn't say that simple. Did she republish? And if she did, therefore, liability. She has an extra step because Ms. Heard has the burden of proving by greater weight of the evidence. This is back to the preponderance of the evidence standard, the lower standard, the oomph above 50%, that Mr. Waldman was an agent of Mr. Depp and that he was acting within the scope of his agency when he made the statement. It's like a double whammy on top of the double whammy that they have to prove later on. Very difficult. There's no burden to prove truth of statements. You must remember, ladies and gentlemen of the jury, that there is no burden on either party to prove the truth of any of the statements. Both parties were free to offer proof of truth, but by doing so, they did not assume the burden of convincing you the truth of the statements. The burden remains on each party to prove that the statements he or she complains of are false. Okay. Now, expert witnesses. Because in this case, we had more than just Amber Heard, Johnny Depp. We had a bunch of other people, and some of them were expert witnesses. So what the hell are we supposed to do with those, Judge? Well, my children, I shall tell you. The rules of evidence ordinarily do not permit witnesses to testify as to opinions or conclusions. An exception to this rule exists as to those whom we shall call expert witnesses. Witnesses who, by education and experience, have become experts in some art, science, profession, or calling may state their opinions. They're the only ones who can do that. Lay witnesses can only say what I saw, what I heard, what I tasted, what I felt. Experts can be like, I opine based on the data that I have received, based on these credentials, this is what I think, as to relevant and material matters in which they profess to be an expert, and may also state their reasons for the opinion. You should consider each expert opinion received in evidence in this case and give it such weight as you may think it deserves. If you should decide that the opinion of an expert is not based upon sufficient education and experience, Dr. Spiegel, Arnold, excuse me, I had something in my throat. Or if you should conclude that the reasons given in support of the opinion are not sound, or if you feel that it is outweighed by other evidence, you may disregard the opinion entirely. So, in considering the weight to be given to the testimony of expert witnesses whose opinions differ, you may consider the ability. I'm sorry, I lost my place. You should consider each expert opinion received evidence in this case and give it such weight as you may think it deserves. You can disregard the opinion entirely. In considering the weight to be given to the testimony of expert witnesses whose opinions differ, you may consider the ability and character of the witnesses, their actions upon the witness stand, the weight and process of the reasoning by which they support their opinion, their possible bias, of course, in favor of the side which they testify, their relative opportunities for study or observation of the matters on which they testify, and any other matters which serve to illuminate their statements. So that's basically giving the jury to understand, like, who the hell are these people? How am I to regard their testimony? Because they're obviously not privy to the situation directly between Amber Heard and Johnny Depp, but they have tangential outside influence about it. Now, the weight of these expert witness opinions. So we learned who they are. Now, what do we do with them? In considering the weight to be given to the testimony of expert witnesses, you should consider the basis for his or her opinion and the manner by which he or she arrived at it, and the underlying facts and data upon which he or she relied. By the way, I'm thinking about doing a piece on the ACLU. Somebody sent me the ACLU motion, and I will probably do it after I'm done with this. We're going to go through because people are really, really hungry for that right now, and I'm probably just going to do it. But I want to finish this first. Expert witnesses and reliable authority. An expert witness was asked whether statements contained in published treatises, periodicals, or pamphlets are reliable authority of a type normally relied upon by others in his or her field of expertise. This is like the separation of experts. We had this methodology, we had this. What do I do with them? The evidence is permitted to test the knowledge, the accuracy, opinion of these experts. Like, who are they? How are they? Does it sound? Is it logical? Is it full? Is it complete? And so on and so forth. And if such evidence is established as a reliable authority by expert testimony, it may be considered by you along with the other evidence in this case. Depositions. In considering the evidence, you are not limited to the bald statements of the witnesses. In other words, you're not limited solely to what you see and hear as the witnesses testify. On the contrary, you are permitted to draw from the facts as you find to have been proven such reasonable inferences as may seem justified in light of your own experience. Boom. So now your own experiences as humans, as jurors, as people, as logical creatures on this planet, you can bring that stuff into the table. You're not living in a vacuum. That is, oh my God, this is like number 2 crucial based. If you want to put it on a scale, I already said what is absolutely crucial. This is number 2, in my opinion. During the trial of this case, certain testimony has been presented to you by way of video deposition. You should give to this testimony the same consideration as to its weight and credibility as you would give to the testimony witnesses who testified here in court. You must not discount any testimony merely because it was shown to you by video recording. This is mostly for Amber's side, but Johnny's side as well, like Kate Moss, for example. Party bound by his or her own testimony. When one of the parties testifies unequivocally to facts within his or her own knowledge, these statements of fact and the necessary inferences from them are binding upon him or her. He or she cannot rely on other evidence in conflict with his or her own testimony to strengthen his or her case. However, you must consider his or her testimony as a whole, and you must consider a statement made in one part of his or her testimony in light of any explanation or clarification made elsewhere in his or her testimony. So basically, there's talking about their knowledge. You can make the inferences from them. Circumstantial evidence. Any fact that may be proved by direct evidence may also be proved by circumstantial evidence. That is, you may draw all reasonable and legitimate inferences and deductions from the evidence. Prior inconsistent statement by non-party witness. If you believe from the evidence that a witness other than Depp or Heard previously made a statement inconsistent with their testimony at trial, this is called impeachment for legal purposes. The only purpose for which the statement may be considered by you is its bearing on the witness's credibility. It is not evidence that what the witness previously said is true. It's actually a pretty powerful instruction, to be honest. Very powerful. It's basically saying, look, if they are inconsistent, it doesn't mean that what they said before is true or what they're saying now is true. Like, you have to decide. That goes back to like instruction 2, the weight of the you decide like who to give more credibility to. If you believe from the evidence, prior inconsistent statement by a party now we're talking about Depp and Heard, the 2 parties. If you believe from the evidence that Ms. Heard or Mr. Depp previously made a statement inconsistent with her or his testimony at this trial, that previous statements may be considered by you as evidence that what Ms. Heard or Mr. Depp previously said was true. So now on those 2, yes, you can. If you believe that they made something inconsistent, like the TMZ, I did not mean to do that. Oopsies. For example, you can infer from that. On Heard and Depp, yes, you can. On others, no. Objections and assertion of privilege. In reaching your verdict in this case, you are to consider the testimony and evidence. Sometimes attorneys stated objections during the course of this trial and instructed a witness not to answer. Objections and instructions to witnesses are not evidence, and you may not consider them in reaching your verdict, nor are you to draw in any inference from the fact that an objection was made. Basically, it's a judge saying, look, it's procedure stuff. Shut up, you stupid lay people. Let us lawyers sort it out. Just ignore this crap. It's mean and it's ruthless, but it's fact, unfortunately. The courtroom is just, it's such a bizarre conglomerate that it's reserved for this elite group, whatever. And the judge just reminding them, like, in a very non-condescending tone of the condescending ramifications of the stuff that they witnessed. And they're like, what's that? Oh, don't ignore it, right? You must not, rejected and stricken evidence. Here we go. You must not consider any matter that was rejected or stricken by the court. So when a witness just keeps, word vomiting on the stand, and the lawyer goes, Your Honor, I would ask that everything after yes be stricken from the record. And the judge goes to the jury, you shall ignore everything that was said after the yes. That's exactly what the jury is supposed to do. It is not evidence and should be disregarded. Amount sued for is not evidence. Any amount of damages requested by a party. This is like a DEP. I've never seen any instruction like this in my life, in my entire career. Wow. Amount sued for is not evidence. Any amount of damages requested by a party. I think it's DEP's team requested this instruction because like they sued for 50 and Amber Heard's like, okay, double that, 100. Yeah, 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 yeah. You know, like any amount of damages requested by a party is not evidence in this case. You should not consider it as evidence in arriving at your verdict. So you can't take like, oh, he asked for 50, she asked for 100. Clearly she has the better claim, you know. So, and she got to go second. So if Depp had sued for 100, Heard would have sued for $250 million, you know, whatever. There's no winning here. They could have modified the original claim, but I guess they never filed an amended complaint, and they didn't really need to. Presumed damage, because their 50 is justified. You know, the two films, Pirate 6 and Fantastic Beasts 3. Presumed damages. That's the way I see it. People disagree with me, but I'm just one man. If you find your verdict for Mr. Depp or Ms. Heard, then he or she is entitled to recover compensatory damages without any proof of actual or pecuniary injury. As a result, injury to Mr. Depp or Ms. Heard's personal and business, and there it is, reputation. Literally, if you want to just narrow down this entire 38-page instruction and you focus on the number one most important word in this entire case, is that word right there on page 34, reputation. Amber is saying my reputation has been tarnished. Depp is saying my reputation has been tarnished. Amber is saying pay me money, my reputation has been tarnished. Depp is saying pay me money, my reputation has been tarnished. That's it. Now, realistically, we know there's a political game here because Amber is trying to validate her claims through the hashtag #MeToo movement, whereas Depp is simply trying to clear his name because of the false allegations. He doesn't care about the money. She does. Humiliation, embarrassment is presumed. Actual damages. If you find either party liable for defamation, then in determining the amount of damages to which the opposing party is entitled, you may take into consideration all of the circumstances surrounding the defamatory statements, the occasions on which they were made, and the extent of their publication, the nature and character of the insult, the probable effect on those who heard the statements, and their probable and natural effect upon the defamed party's personal feelings and upon his or her standing in the community and in the business. Your verdict should be for an amount that will willfully and fairly compensate him or her. Now, finally, we come to the garnish, right? The dessert. Number one, any loss or injury to his or her business. Number two, any insult to him or her, including pain, embarrassment, humiliation, mental suffering, anguish, right? Number three, any injury to his or her reputation. There's that word again. Number four, any actual out-of-pocket losses caused by the statements. Mr. Depp cannot recover damages for any harm that occurred after November 2nd, 2020. Ms. Heard can recover damages for any harm that occurred after Mr. Waldman's statements were published. So they're establishing the timeline. You can't go back to like 1995. You're limited during this time frame. Reasonable proof. The burden is on the party seeking damages to prove by the greater weight of the evidence each item of damages he or she claims, and to prove that each item was caused by the defamatory statements at issue. Neither party is required to prove the exact amount of damages, but the party must show sufficient facts and circumstances to permit you to make a reasonable estimate of each item, logically so. If either party fails to do so, then she cannot recover for that item. Punitive damages. Now, this is where it gets sexy. This is where the case gets really sexy. punitive damages is something that you like. If someone acted in a way that was intention, well, let's talk about it. Let me read it first. If you have found, this is if now basically this is the last thing that they get to discuss after they, let's say they find everything, they agree with one side or the other, hopefully Johnny's. Once they agree, they're like, all right, if you have found by clear and convincing evidence that the statements in the op-ed were made with knowledge that they were false, or so recklessly as to amount to a willful disregard of the truth, that is, with a high degree of awareness that the statements were probably false, then, right? There's the if, there's the then. This is like a law school admission test example, I swear. One day this is going to end up in fucking LSATs in the future. I can literally see it happening. Then you may, optional, it's not guaranteed. May, it's not a must. Remember, must, this is may. May is you could. May, could. Must is shall. May is could. Award punitive damages to punish misheard. Punish, there it is. Punitive. For what you did, you can punish misheard for such actions and to serve as an example to prevent others from making such statements in the future. You must state separately in your verdict. So there's going to be a separate line for that. And I don't think I have those, but we're not going to go through them. There's no need for that. That's for the jury to decipher. I'm just focusing on the instructions. So please don't send those to me. I beg you. I'm already drowning in messages. You must stay. And by the way, I appreciate every single one of you, but sometimes something happens, somebody tweets something, and I get like 50 messages on just that one thing. And it's very, very hard sometimes to keep up. But I appreciate all your messages, and I'll try and return each and every single one of them in due course, even if it's just one word or an emoji or something. You must state separately in your verdict any amount you allow as compensatory damages, if any, and the amount you allow as punitives. And same thing for the other, for Amber Heard, if you found by clear and convincing evidence that Mr. Waldman, while acting as the agent, made the statement with false or reckless disregard, blah, 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 same language, then you may award punitive damages to punish Mr. Depp for such actions. And you must also state that separately. Whew! That was a mouthful. 38 pages. I mean, poor jury. They had to sit there and listen to all of that. And then, of course, comes the verdict forms, and that's where they're going to fill out. Like, we find for Johnny Depp, we find for Amber Heard, this is the amount. This is how much we think is just. So, like, can they both win? I don't think so. I don't think so. Even legally speaking. I mean, logically, it doesn't make sense. Like, he defamed her and she defamed, because they're both kind of linked, right? One is saying abuse, the other saying, no, it's abuse hoax. They're mutually exclusive. They can't both be, yes, it's abuse, and yes, it's abuse hoax. So in a utopian world, even, it would not work, because they can both fail, yes, but they can't both win, because then you're saying, yes, she was abused, then you're going, I'm sorry, she wasn't abused. Wait, she was, the defamatory statement is true, and then you're saying, but yes, also the hoax statement is true. Like, what? What the hell are you talking about? It doesn't make any sense. It has to be cogent, sound, logical. It doesn't make any sense. So that's the way I see it. That's the way I see it, because it doesn't make any sense at all. But anyway, I hope you enjoyed this. I wanna end right here. I'm going to go live literally in about 5 seconds as soon as I get this up. We're going to be talking about the ACLU one. Let's see. Let me just make sure I got it. I think this is it. It is hereby stipulated and agreed by between the undersigned that the return date, production expenses be adjourned. Yep. And then the affirmation of Stephanie, Mr. Depp did this, and this, and we want money. Where's the detailed? I'm like a senior associate. Yes. Okay, but do they have the money at the end there or no? Hereby certified that the affirmation incurred prior to filing ACLU, non-parties, detailed description. I'll have to review it. And then I'm live right now. Yes, I'm live right now, and I'm going to go live in just a minute. So thank you all for joining me. I hope you enjoyed this, and I will see you in my next video in about a few seconds.